Hi everyone. Welcome to today's webinar, a closer look at high conflict custody, unmasking post-separation litigation abuse. I'm Jamie Davis, a board certified family law specialist and co-managing partner at Gaylor Hunt Davis Taylor and Gibbs in Raleigh, where I practiced exclusively in the area of family law for almost 24 years. I am pleased to be here with you as we take a deeper dive into the patterns and realities that often lie beneath the surface of so-called high conflict custody cases. As legal professionals and advocates for families, many of us have encountered custody disputes that seem intractable, where conflict persists no matter the intervention. But what if the entrenched conflict isn't really mutual? What if it's the product of one parent weaponizing the legal system while the other is simply trying to shield themselves and their child? Today, we'll challenge assumptions, explore the concept of asymmetric conflict, and confront how post-separation litigation abuse often hides behind the high conflict label, misleading professionals and putting children at risk. We are fortunate to be joined today by two deeply experienced and insightful professionals who bring decades of frontline experience to the discussion. First, Al Huntoon is a seasoned co-parenting specialist with over 30 years in family services and mental health. A former custody mediator, Al has worked closely with families navigating high conflict separation, shared parenting, and complex transitions. His approach sheds light on the often overlooked dynamics of asymmetric conflict, those cases where only one parent is driving the turmoil. Al's perspective challenges conventional wisdom and offers practical, emotionally informed insights for both professionals and parents. Joining him is Suzanne Chester, a public interest attorney with nearly 3 decades of experience representing parents and children in complex custody and domestic violence cases. Now launching her own solo practice in Wake County, Suzanne is focusing on guardian ad litem work and representing children directly, particularly those involved in 50B proceedings. Suzanne is a passionate advocate for the child's voice in custody litigation and has spoken nationally on promoting children's best interests in family court. Her work continues to expose how the term high conflict too often masks abusive behaviors that evade proper scrutiny. Together, Al and Suzanne will help us reconsider what we think we know about conflict in custody cases and help us identify what justice and protection should really look like when a child is caught in the crossfire. And with that, I'll turn it over to Al and Suzanne.
Okay, well, thanks, Jamie, for that kind introduction and for setting up the webinar so eloquently. And also, I want to thank the NC Bar for hosting us today. And I do want to thank all the attendees. We really appreciate your attendance and participation. So let's just jump right in. Here's our agenda today. I'll be covering the first 5 topics. Suzanne will be covering 7 through 10. There's a lot of material to cover, so we'll be going very quickly. If you want to put some questions in the chat, we'll do our best to answer them after the presentation. There could be a lot of attendees, so we'll do our best to get to your question today. So what are the learning objectives? For my section, it's going to be to define the asymmetric conflict and contrast it with mutual high conflict and recognize the patterns that are associated with asymmetric conflict and then get a good understanding, a good foundation of the risks of this kind of coercive litigation. So you'll be hearing 2 perspectives today. Mine's a systems-based view, and Suzanne will be taking a legal lens to look at this. There'll be some overlap. Hopefully, the overlap will help promote a deeper understanding and not be redundant. And what we're hoping for is to create a holistic approach to this issue. As we explore this topic today, I encourage you to keep this in mind. Beyond the paperwork, beyond the legal maneuvering, beyond the courtrooms, there's a child, not an abstract concept, not a statistic, but a real living child who's being pulled along without choice, without warning, without agency. Children don't experience conflict in terms of legal complexities or procedural battles. They experience it as uncertainty, as instability, as fear, as pain, as a storm they cannot escape. And the storm we're examining today isn't what it appears to be. It's not two parents locked in mutual engagement. What often hides behind the high conflict label is something far more insidious. One parent systematically orchestrating conflict through strategic exploitation of legal processes and procedures, while the other simply tries to weather the assault. Yet our system typically labels both parties as difficult, both as uncooperative, both as high conflict. When we fail to recognize the difference between asymmetric conflict and mutual hostility, we don't just misdiagnose the problem, we unwittingly perpetuate it, participate in it. And children, already vulnerable, become collateral damage in a system meant to protect them. The type of asymmetric conflict doesn't just distort the reality of the case. It creates a new layer of complexity for attorneys and courts to navigate. When both parents are automatically labeled as high conflict, we risk perpetuating a cycle of instability. The child caught in the middle doesn't experience this conflict as the parents do, a set of legal battles. They experience it as trauma. And until we start to recognize and address these imbalances, this legal process will continue to fail the very children it was established to protect. So before we jump into a detailed examination of the topic, I'd like to provide a little context. As you may know, historically, custody law was closely linked to property rights, with children regarded as extension of parental authority, uh, like land or assets. Early court decisions treated custody disputes like property settlements, favoring paternal ownership as a natural extension of a father's legal standing. Over time, legal norms shifted, favoring mothers as natural caregivers, framing custody as a matter of nurture rather than ownership. As societal values evolved, children's rights movements gained traction, and custody laws moved away from rigid parental entitlements and toward best interest of the child standard. This transition hasn't been seamless, and even today, remnants of the old system persist. Courts still struggle with applying subjective definitions of best interests of the children, balancing parental rights, and addressing systemic biases. In short, our family court system still retains elements of a transactional mindset, which creates vulnerabilities in cases of asymmetric conflict. When one parent manipulates legal mechanisms, they are effectively exploiting a system originally built to fairly divide property rather than safeguard against strategic abuse. Courts, grounded in neutrality and resolution, often default to assigning equal responsibility, even when the reality is far more complex. This approach frequently mislabels systematic coercion as mutual conflict, reflecting the remnants of the outdated legal frameworks that prioritize dispute resolution over recognizing power imbalances. So when a parent strategically weaponizes filings, delays, or noncompliance, the court, still tethered to its adversarial roots, can struggle to differentiate between harmful litigation tactics and legitimate conflict. The consequence? The child remains caught in that storm, framed as a legal dispute rather than recognized as a crisis requiring intervention. Mislabeling coercive litigation as mutual hostility doesn't just fail justice, it actively harms children. When neutrality is mistaken for fairness, the system risks becoming complicit rather than corrective. So let's talk about the stakes. I suggested some of them. there in that introduction. There's individual consequences, emotional and psychological. Targeted parents and children endure ongoing trauma uh, due to repeated legal exposure, financial harm and costs, and fear. Courts risk enabling abuse when failing to distinguish between mutual and asymmetric conflict. And the system uh, can experience a failure, eroded trust that can lead to cynicism and burnout. So, how do we define this issue, post separation litigious abuse? It's a strategic misuse of legal processes by one party, typically after separation or divorce, to harass, control, exhaust, or punish the other party under the guise of legitimate legal action. It's a form of coercive control, weaponizing the court system to perpetuate abuse, especially in custody disputes. So, how is it different from mutual high conflict? Well, that involves both parties fighting for favorable settlement terms. Both parties are uh, engaged in a legal battle because they want the best result for them. Um, but it isn't about perpetuating abuse. So here's some hallmarks of this litigious abuse. It prolongs the conflict to drain the targeted party's resources. It exploits the adversarial nature of the court system, masks coercive control as mere conflict, and the focus is on inflicting harm, not resolving the issues. It's not on resolution. So what's happening is that the party driving the conflict is taking advantage of the myth of equal standing, or what I call the illusion of procedural parity. Uh, in court, both parties have access. Typically, in these cases, they both have attorneys, but that does not mean that they have equal power. Legal symmetry does not equal fairness. And because one party can use the process to dominate, to coerce, to abuse the other party. Why do some standard interventions fail? Well, mediation operates on assumptions of an even playing field and both parties act in good faith. These are foundational principles of mediation. And coming in with that assumption, then it's hard to address these power imbalances. Co-parenting classes in particular don't address coercion or abuse. They assume that parents have a cooperative intent and they just need some skills building to operationalize that. And parenting coordination often focuses on neutralizing conflict rather than contextualizing this. This this can suppress rather than address the drivers of this kind of dysfunction. So, how do we identify these toxic disruptors? What do they look like now that we understand the kind of the broader definition and hallmarks of the issue? So, the reason that I'm using the term toxic means that we're focusing on the behaviors, and you'll hear this over and over again, behavioral patterns, not labels. So it shifts the conversation toward understanding destructive patterns without pathologizing. So here, if you're family court, divorce, custody professional, you hear terms like narcissistic or borderline personality disorder thrown around all the time. And those labels are not helpful in really identifying the problem. We need to focus on the behaviors. So, how does this look in terms of these behavioral patterns? So, uh, there's two different kinds of patterns that I've identified and labeled. These are my labels: a defiant disruptor and litigious disruptor. They both have the same intent, which is control, not cooperation, not resolution. As I said, it's indicated by behavior. Their behavior attempts to maintain plausible deniability, and the way they do that is they exploit ambiguity to sow confusion, stall compliance, and reinforce control. So the first type is a defiant disruptor, and Suzanne is going to talk about some of the indicators, some of the behaviors for defiant disruptors as well. They tend to be passive aggressive. There's subtle, consistent non-compliance, things like forgetting paperwork, missing deadlines, stalling. There's always an excuse. There's always a reason, rarely responsibility. The communication style is, delayed, vague, partial replies to inquiries that won't commit to timelines. And this is all in service of creating confusion, not clarity. So with professionals that often appear to be pleasant or compliant, but sometimes confused and overwhelmed. They fail to follow through, subtly blaming the system for their failings. So the litigious disruptor is more aggressive. The defiant disruptor tends to be passive aggressive. Litigious is aggressive aggressive. There's high volume filings framed as emergency. Often there's overuse of enforcement actions, lots of show cause and contempt filings, and then the system's flooded with documentation. The documentation, it often takes a form of excessive, overly formal emails. There's use of legal language. This is something that I noticed when I was a mediator. Use of the term we. We're doing this, we're doing that, we're doing the other thing. I would ask people, who's we? It would just be the two parents in the room. Who's we? My lawyer and I, my attorney and I. So there's this identification with over identification really with the legal team, not the co-parent, not caregivers, not the child. So there can be frequent attorney changes, sometimes combined with periods of pro se representation, accusations against neutrals, even to the extent of fine complaints or grievances. So how do we differentiate that abuse from legitimate concerns? This is where the rubber meets the road. There's these two broad patterns. How do you use those to distinguish this abuse, this asymmetric conflict from legitimate legal strategy? And so this is what to look for. Again, these are patterns. Are they legitimate concerns or strategic attempts at intimidation? Show cause motions, you saw all the time. Just the filing of a show cause motion can be very intimidating to the other party. Are they identifying technical violations, procedural missteps, or compliance failures? Are these real arguments? So patterns matter. The frequency, the timing, these things are indicators if it's asymmetric conflict. So this is what to look for, relates to what I just talked about: attorney churn, asymmetric volume of filings, focus on technicalities, undermining neutrals, failures to settle despite opportunities. Even when the settlement might be favorable to the party, they'll continue the legal battle. So this is an emergent issue, and there's some different screening approaches that are being considered, and the indicators are related to the red flags, of course. Who's cycling through the attorneys among the two parties? Do the filings escalate rather than work toward resolution? There's this excessive documentation with legal language in terms of emails or texts. Are genuine resolutions blocked rather than engaged with? So in order to establish patterns, you really need documentation, which means tracking events chronologically across domains, which is difficult because it's very siloed because of confidentiality and privilege. But checklists and summaries could clarify the difference in the approaches between plaintiffs, defendants, or movements and respondents. And these tools could offer a structured approach to case management, streamlining evaluation, identifying these patterns and clarifying the underlying dynamics. So here's my takeaways for you guys. Not all conflict is mutual. Some of it's high conflict, but much of it is actually asymmetric abuse. Litigation can be used as a weapon. Um, Patterns matter more than events or incidents. In order to really determine this, we have to look at patterns over time in filings, communications, and interactions. There's these two distinct tactics with one underlying intent, with a passive, with a defiant, and then a more active with the litigious disruptor. And the failure of the system to address this has emotional and institutional costs. The targeted parents and children suffer harm. The court, it erodes court legitimacy. And, I think people face burnout and, there's an accompanying ethical dilemma with that. So once we begin to recognize this asymmetric conflict, we start to see how frequently it plays a part in prolonged custody disputes. That happened to me. I started to see it, one person driving the conflict. Once I noticed it, I saw it, that it wasn't rare. I'm not saying it's common, but it did happen quite a bit in mediation. So once you recognize that, that's not enough, because then we have a duty to shift from neutrality to informed corrective action. And so, once you start recognize it, what comes next? Awareness is only the first step. Responsibility is realized through action. What that action looks like is up to each professional individually, but it requires an active stance. So that's my part of the presentation. We're going to examine some of the research and consider some examples and applications. And with that, I'll turn it over to Suzanne.
Thank you, Al. I'll share my screen here. Whoops. I don't know what happened there. I just lost something. Just give me 1 minute. Maybe while I'm figuring this out, you all want to put some questions into the chat box.
You're welcome, Kat. Thank you for your kind comment in the chat. I would happily give this presentation to family court judges wherever. That's the question in the chat. Al, do you travel to other states? I would prefer it be a video conference, but I would consider doing it in person.
So I'm on slideshow. Can everybody see the slides?
We're seeing edit view.
Okay, so I need to go to play from store. Great. Everybody just see the slide now?
Yes.
Great, thank you. So welcome everybody, and thank you, Al, thank you, Jamie and Brianne, for setting all of this up. It would be great to hear what parts of the state and also from other states everybody who's participating is from. Maybe you might want to make a note in the chat box. That would be cool. So I'm going to start off by looking at how the National Council for Family and Juvenile Court Judges in the US, what their position is on the issue of high conflict. And I'm starting off with a quote from a publication by a group of judges who were putting together a judicial guide for child safety in custody cases. And if you see from this characterization here that they acknowledge that family law cases involving evidence of abuse are in fact actually high conflict. They may have some high conflict. I'm sorry. Family law cases involving evidence of abuse are often wrongly labeled high conflict. They may have some high conflict characteristics, but they require a different set of considerations to promote safety for the at-risk parent and for the child. The publication goes on to define high conflict cases broadly as being distinguished by mutual mistrust of each partner, poor impulse control, and cycles of reaction and counter-reaction. I know probably most people on this webinar are familiar with that. Then they note that in cases with abuse, it's one parent who's exhibiting the attitudes and the behaviors that are designed to exert this control over the other parent. Now, these cases are not straightforward. To add to the confusion, there may be responsive violence or protective behaviors by the victim parent. So it may make the case look like it is high conflict on the surface. But as Al has done, we're going to try to go below the surface. So my focus today is going to be on the type of high conflict case where there has been a history of domestic violence throughout the couple's relationship. And this domestic violence then extends as coercive control, including litigation abuse after the separation. The research shows that this particular type of high conflict case tends to be largely female victims with male perpetrators. And I would point you to a recent study in Canada where Professor Nick Bala and some of his colleagues, they examined 3 years of court findings, court orders essentially, where the court had found that abuse had occurred and made an award of costs. There, the differences between the genders were much closer. Male, 53% likelihood of being the perpetrator, and female, 47%. What was particularly interesting to me was that most parties in those cases who were found to have engaged in litigation abuse actually had attorneys. So I know I'll talk some about the best interest standard, and I just want to talk about it a little bit more. It is a very flexible standard, and it allows judges and court professionals to exercise great discretion. And that has one huge advantage. It allows the judge and other court professionals to, tailor their recommendations, or in the case of the judge, their decisions to the individualized needs of the child. One of the drawbacks is that that discretion at the same time allows in the back door subjective value judgments by our judges and us as court professionals, biases and stereotypes, gut feelings and preconceptions. A couple of examples of these. I've seen this many times over my career, and if anyone wants to, make a note in the chat box whether they're familiar with some of these, please do. Well, first of all, the biggie is in a high conflict case, the conflict is mutual and both parties are at fault. I've heard it takes two to tango any number of times. Domestic violence is no longer relevant because the parties are separated. Unfortunately, that ignores the coercive control that often continues post-separation. And the third one is I represented a lot of domestic violence victims earlier on in my career, and it wasn't unusual to see this, but I certainly have seen it quite a few times when I've been representing children directly. But expecting a parent who's been traumatized by domestic abuse during the relationship to all of a sudden be able to dust herself off and co-parent without a problem. So let's look at what the research tells us about high conflict. It's interesting because it's pretty consistent over the last 30 years. It's estimated that about 20% of divorcing parents go to court to get custody decided, and the others are able to get it resolved themselves. The other, like 80%. Of the 20% who go to court, only about 4 to 5% actually go to trial, and it's among this group of cases that many of them are designated as high conflict. Research shows that the majority of this 4 to 5% have a history of domestic violence concerns, including concerns about child maltreatment. And I've given you cites to some researchers and some other family court professionals who have written on this issue. So what do we mean by domestic violence? The way I'm using the term is, on the one hand, there's the physical violence a lot of the time, and it may be, one of a whole myriad of types of physical or sexual violence. On the other side, there's often, as part of the domestic violence, this coercive control, and it may take any of the forms listed there, and I know I've missed a whole bunch of them, but oftentimes then the litigation abuse continues the coercive control that was already there in the relationship. So Al's already spoken about this, and I want to add a few points from a legal perspective. How should we, or how can we recognize litigation abuse? I think there's three very important factors, and one is looking at what the history of the relationship is before the parties came to court. Looking at the behaviors of the person that you suspect may be engaging in litigation abuse, and then looking at the effects. How is the other parent being affected by the litigation abuse? So many of you may already do this, but to get what I think is some good information about the history of a relationship and to get some good understanding of what was happening between this couple before they came to court, as part of your intake, I think it's really important to ask questions specifically about domestic violence, but not limiting it to the words domestic violence, because a lot of people think that means, was I physically hit? Including questions about coercive control, other forms of controlling financial behavior, asking about did the parties ever file for a 50B? And for those of you who aren't from North Carolina, 50B is our version of a domestic violence, it is a domestic violence protective order. Were there ever any criminal charges pending against either of the parties? And this information is really useful, regardless or not of whether the protective order was actually granted or whether or not there was a conviction. As we know, oftentimes there is domestic violence and neither of those things may have happened. CPS reports can give a really excellent insight into the dynamics of what's going on in the family and how the child is being impacted. And again, I would emphasize that it really doesn't matter whether or not CPS ended up substantiating or not. Frequently cases where there's no substantiation, the records can give important information about the dynamic of the relationship and what was going on. So behaviors of the person who's engaging in litigation abuse. From when I did a lot of domestic violence work, what I saw happen, not frequently, but regularly enough for it to be a major problem, was the defendant, once served with a copy of the domestic violence protective complaint, would go to the courthouse and file a cross-claim for domestic violence protective order. And that would create all types of issues down the road. But for now, I'll just stick with describing the behaviors. Refusing or delaying disclosure of financial information. I mean, that happens all the time, and it puts the party who has disclosed and oftentimes is much lower income or certainly lower income at a massive disadvantage. Choosing to go pro se, I was reading in the research that that's a pretty common tactic. So we all know that we have a huge problem across our court systems nationally with massive numbers of pro se litigants. And I'm not talking about that where people can't afford to get attorneys and they have to be pro se, but choosing to go pro se is something that somebody who's engaging in litigation abuse may have chosen to do because it gives them the advantage of having very direct contact with the other parent, for example, on cross-examination. They have the ability to get up close to the target parent, to cross-examine them. In depositions, the same thing. And another forum, it allows more immediate contact with the target or the victim of litigation abuse. One behavior that really, really bothers me as a former attorney, as an attorney who formerly represented children, was when a parent would harass a professional who was treating a child. I had a number of children who were being treated by therapists where the therapist just couldn't deal with the continuing harassment, whether it would be voicemails full of messages, blowing up their email, making threats to report them, and then they declined to be involved. Other behaviors, and this I think probably applies more in rural areas in particular and outside larger cities, where the person who's engaging in litigation abuse will make a deliberate and intentional attempt to conflict out legal aid or private attorneys. It's particularly problematic if there are very few attorneys doing this kind of work in a geographic area anyway. Repeated requests for continuances. Al talked about the attorney churn. What I've seen a lot of is the abuse of parallel systems during the litigation that's going on in court. For example, malicious complaints, malicious reports to Child Protective Services. And most perpetrators of litigation abuse, they're smart enough not to actually make the report themselves because at some point that's likely to come out in the litigation. But they may have somebody else do it so as to distance themselves from having made it. In the immigration arena, the one parent intentionally not taking the steps necessary to make the other parent legal, asking the police to do totally unwarranted wellness checks. Violating court orders. I think, Al, you referred to that as the defiant disruptor. And there's so many ways of making the litigation, as you all know, just ramp up and continue forever, withholding child support. So that leaves the target parent in the position of having to go back to court to enforce it. And I'm not talking about child support that's done through an agency, but in situations where it's part of the child custody order, then it means the target parent, they either have to accept that they're going to get less child support or they have to go back to court to file a show cause. Refusing to comply with parenting time provisions. I've seen a number of cases where a parent is given specific visitation time, custodial time, whatever it may be, and the other parent and child are to meet in a public place. The parent doesn't show up, doesn't give notice, or shows up really late and then returns the child late or very early, all of which makes it extremely stressful, unpredictable, and painful for the child involved as well as the target parent. Withholding consent for treatment, that's another issue that I've seen quite a number of cases, and I'm sure you all have too, is where the court order indicates the child is to get certain treatment. Let's say it's some type of therapy, and the parents are not able to agree on who the therapist should be, and it just becomes a never-ending cycle of withholding consent. Withholding insurance information, that's a biggie. And sometimes it goes past even withholding, but I've seen parents where one parent is on Medicaid and the child is on Medicaid, then making false reports to Medicaid that the parent is engaged in insurance fraud. Looking at how the litigation abuse affects the targeted parent, was the kind of third prong that I'm suggesting as ways for identifying litigation abuse. And the research shows that coercive control without any physical violence has similarly negative effects on the target parent. And I've certainly seen represented any number of parents who are just filled with fear and dread and anxiety at when is the next shoe going to drop in the litigation. The financial harm is enormous. Just think about, the parent who asks for several continuances. If they're granted, that means the other parent has to take a day off of work every single time, has to find daycare for the child or children, is really jeopardizing their own employment, because most employers, regardless of what the law may say, don't like it when employees are out in court on multiple occasions. They see their children suffering the consequences, probably one of the more painful aspects of the effects. But most of all, the onus is now on the targeted parent to enforce the court order. It's up to that parent to go back to court to either file a show cause, a motion to modify, whatever it may be. And with all of the financial consequences involved, as well as the psychological consequences, you can well understand why many parents choose not to go back to court, even though these harms may be occurring. So the immediate effects on children of litigation abuse is something I want to touch on briefly. I'm not going to try to talk about the long-term effects on children of litigation abuse, because one, I don't know what they are, but I do know there's a huge body of research about the long-term impact on children of domestic violence. But for purposes of this webinar, I'm just going to talk about some of the a few of the effects that I've observed and that are in the research. Depriving the parent and the child of financial support. And so the effect of this may go from very basic needs not being met to extracurricular opportunities being missed out on. I've represented children who were unable to go to camp because, camp costs money and child support wasn't getting paid. Children who aren't able to get the tutoring that they need because child support may not be getting paid. And I know from representing enough children who had parents in court that they feel the anxiety. I had one child tell me that his mother would always whenever his mother was wearing her Sunday best and it wasn't a Sunday, it meant she was going to court. The unmet hopes and expectations. I represented one child who was really desperate to have more time with her dad, really wanted him to show up at his court-granted visitations. But what she ended up finding herself in was having to go for the exchange, and about half of the time he wouldn't show up. And so, in the meantime, in the litigation, he's accusing the other parent of withholding the child or alienating the child. And in fact, many of the times he's not showing up. And my child client was devastated by it. The embarrassment of CPS investigations, that's another one that children really suffer from. I've had clients, taken out of school so that they can be interviewed by a CPS, by the caseworker. The CPS goes to their home and they have to go into a separate room and talk to the CPS worker, being asked intimate questions sometimes. Super embarrassing for a child, and a really important part of the litigation abuse. Healthcare appointments, that one, I see the problems with healthcare appointments in these cases really tie into the proclivity to grant shared decision-making and shared legal custody in these cases, regardless of how the parties get along. And so what happens, or what sometimes happens, is a child goes to the doctor and both of the parents are there, oftentimes in the same room. I mean, imagine, put yourselves in that situation. How would you feel if you had to go to the doctor and your two parents who clearly hate each other and one is really fearful of the other and there's a lot of anger and you have them there in the doctor's office? Ways of addressing litigation abuse. So I was reading a California case recently, and I couldn't find the site as I was preparing these slides, but in that case, the judge had considered litigation abuse as a best interest factor. And it makes perfect sense in North Carolina for that to happen, since really any factor under our case law is relevant to best, or not any factor, but many. And certainly in this case, the judge had taken note of the effect of the litigation abuse on the target parent and the ability of the target parent to actually parent, how it impacted the parenting, and found that as a best interest factor against the perpetrator. Awarding attorney's fees to the target parent when the other parent files a frivolous motion or a claim. That article that I referenced by Bala and his colleagues addresses attorney fee awards. I know in Canada they're much more often awarded. It's not as common in the US. Another way of addressing is actually making a real contempt finding when there has been proof of an intentional violation of a court order. I think it's really important, especially as people are coming back to court multiple times, that there be good documentation of what the court actually found, because especially in districts which don't have one judge assigned to one family, it's really important that there be a written history of what the findings were. Al already talked about the need to not just be neutral, but to intervene as needed to protect. I'm a firm believer in the value of education, and I think it's so important that court professionals and judges have ongoing training on coercive control and on trauma. We use the term trauma and traumatized a lot, but having ongoing trainings on how trauma actually affects a victim and how trauma affects children could be really useful in this arena. Hearing the voice and perspective of the child early in the process. There's a webinar that I include in the resources. It was moderated by Peter Jaffe, Dr. Jaffe, who's an expert in the area of domestic violence, and there's several people who speak in the webinar, and there's actually a young man who had lived experience. Well, lived experience is an understatement. He had 19 years of dealing with litigation abuse by involving his parents. And the judge who speaks on the webinar talks about the importance of hearing from the child early on. Then attorneys who represent victims in these cases, for them to have as much training as possible in how to synthesize the stories so that the professionals who are involved are able to, get a sense of the historical context, easily. Supporting attorneys who are representing victims of litigation abuse, because as you know, those attorneys often get complaints filed against them. And I guess the last question that I'm certainly not going to answer, but it's one that's a really important one, is what is our responsibility as attorneys when we see attorneys go from zealous advocacy to facilitating litigation abuse? In the resources that I've laid out here, some of them I've already talked about. The National Family Violence Law Center has recently released a very good 3-hour training on coercive control, not directly on litigation abuse, but on coercive control. The study that I mentioned in Canada about the awards of costs, that's also included in the resources. So I see that we have a few minutes, and hopefully there are some questions, and I'll leave a screen up with Al and my contact information there. But thank you very much for listening.
Yes, and thanks for all the interactions and comments in the chat. I really appreciate that. It's great to see that, especially when you're doing a Zoom, a video conference like this. Someone asked, can we get copies? Yeah, the recording is available. If you want to contact us about our slides, you can email us. You're welcome, Stephanie. So we do have a few minutes. We can take some questions if people want to chime in. One thing I'll say is, it's a pro tip if you're giving a presentation like this to take a deep breath. And I'm glad I did, because I didn't breathe during my entire presentation, and I only passed out. I lost consciousness at the end, just briefly. Have judges been responsive to this concept? Too early to tell, I think. Some of the comments in the chat have been about presenting to judges. I don't want to speak for Suzanne, but I'd love to get this information in front of judges. I think that's critical, and not just judges, others too, GALs and parenting coordinators. I really think could benefit from this. Parenting coordinators are in a unique position to be able to determine if the conflict is asymmetric and act on that behalf. They're in a really unique position to have some insight about that.
I see that Melissa has made the point that she had a judge enter a gatekeeping order against a mother who filed motion after motion against the father. And I think a gatekeeping order, when you're able to get one, may be very effective. It is a very high bar, because obviously there's a strong public policy interest in keeping the courts as open as possible. So there's a high bar for getting a gatekeeping order. But certainly when the behavior is so egregious, then I believe it may be possible to meet it. Also, go ahead.
I'm going to say there's a question about a checklist for family court professionals and others. I have been working somewhat on a screening and a deeper assessment. I would like to partner with hopefully like a psychologist. had some conversations with a psychologist who's also a parenting coordinator about that. I can do that based on, the information, the red flags that we've identified. But I would like to, have a way to have it be more empirically based. And I can't do that on my own. I'm not associated with the research institution or university, which I think that really kind of requires.
Lee makes the point that the children were not hurt in inverted commas, so the DV is not relevant to custody. Well, that really, and I understand that is a common assumption, misconception, and it flies in the face of just volumes of research that children are badly hurt, whether or not they're physically hurt or not, but they're badly hurt psychologically by being exposed, by being in a home where domestic violence is taking place.
So the recording is going to be sent out by tomorrow, and we'll share the slides. I'm okay with that. Also, going to be sending out a brief survey. We'd love to get your feedback. Please complete the survey. It's just 4 questions. And, I love networking with people. I love having professional conversations with people about these issues. Please do not hesitate to email me. I'd love that.
Likewise with me. And I can't believe it. It looks like we're ending a few minutes early. You did have time to breathe after all, Al.
Yeah, yeah. Well, I did, like I said, I passed out briefly, but during your presentation, I just took a few deep breaths and grounded myself.
I see a really important comment here that I want to draw attention about. It's from Catherine. It's important to understand the information behind the data and patterns. Multiple attorneys is a metric that has been kept nationally and is often identified as a victim metric. I have seen that pattern as well, that sometimes that on its own, regularly changing attorneys does not mean that the person's engaging in litigation abuse. I think it's one factor to consider in combination with multiple other ones. I've seen it happen a lot when there are, well, not a lot because it's not that many cases, but cases where there's allegations of child sexual abuse. I've seen multiple changes of attorney by the protective parent. And then I've also seen it in domestic violence cases. So that point is well taken, Catherine.
Yeah, I think that's the point that's I kept emphasizing. It's a pattern of behavior, not just one thing. That's what makes it difficult. It's nuanced, but it is also worth investing in discerning where those patterns are present because ultimately children are suffering. Um, and one thing that I want to emphasize too that I saw is withholding consent for treatment. I just had a conversation with a client yesterday about that, where the dad was consistently withholding or withdrawing consent for play therapy for a 4-year-old, and saw it very consistently as an issue in mediation. Um, Eleanor is asking about highlighting the question about what you can do about the attorneys who allow litigation abuse to continue.
I think one thing that you can do is call them on it. It may not make any difference. I mean, we probably know the attorneys, for those of us who practice in Wake, we probably know there are a small number of attorneys who do that. Probably calling them out. I don't think you get anywhere with filing, bar complaints because they are doing something they have a legal right to do. That's the problem with litigation abuse. Almost all the stuff they have a legal right to do. Um, Um, any attorneys in the audience who have some suggestions for how to deal with an attorney who's facilitating litigation abuse. Perina Meyer, thank you for including the comment about the model code by the National Council of Judges, including litigation abuse in its definition of abuse and coercive control. That's a really important model code, and that's another resource to look at. As for attorney's fees, get an order of protection when an attorney is engaging in litigation abuse. Attorney's fees, I think, is probably the more direct route to, as long as obviously you can show at trial. The problem is it still means you have to try the case, but maybe it would be a deterrent for future abusive motions. Well, it's 2:01. I think we should wrap up.
Yes, indeed. And just want to thank Jamie and thank the Bar Association again for hosting us. I really appreciate it, and I appreciate everybody in attendance. All the comments and interactions is so meaningful.
Me too. It's super exciting to see all the engagement from everyone. And thank you so much, Jamie, and everybody that Al just thanked.